Hello, this is Dr. Grande. Today's question is, can I analyze the case of Ernesto Miranda and the pivotal 1966 Supreme Court case, Miranda versus Arizona? Just a reminder, I'm not diagnosing anybody in this video, only speculating about what could be happening in a situation like this. If you enjoyed this video, please like it, subscribe to my channel, and consider supporting me on Patreon. I will put the link to Patreon in the description for this video. First, I'll look at the background of this case. I'll move to the timeline of the crime, then offer my analysis. Ernesto Miranda was born in Mesa, Arizona on March 9, 1941. He went by the name Ernie. He had a strained relationship with his father, and his mother died when he was 6 years old. Ernie often kept to himself. From a young age, Ernie had behavioral problems. When he was 14, he was convicted of burglary and sentenced to a year in reform school. Over the next several years, he was arrested for armed robbery, burglary, assault, and other offenses. In 1958, he enlisted in the U.S. Army. About a year later, he was dishonorably discharged after being absent without leave multiple times and looking through windows in an effort to see people engaging in intimate activities. He had been ordered to receive mental health counseling, but he only attended one session and was not assigned a diagnosis. Ernie ended up traveling to various states. He was placed in jail in Texas, and he was arrested in Tennessee for possessing a stolen vehicle. He was sentenced to about a year in federal prison for that offense because he had driven the vehicle across state lines. He served his time in Ohio and California. After being released from prison, Ernie had a few different jobs and eventually became a laborer for a produce company in Phoenix, Arizona. Now moving to the timeline of the crime. On March 3, 1963, an 18-year-old movie theater concession stand worker finished her shift in downtown Phoenix and boarded a bus to make her way home. She was referred to in court documents as Lois Ann Jameson. I will call her that, but as I understand it, this name is an alias. Lois was described as mentally disabled. It is believed that she had a low level of intellectual functioning. When Lois exited the bus and started to walk toward her residence, she noticed a vehicle nearby. It was a 1953 Packard, which was being driven by Ernie Miranda. The vehicle belonged to Ernie's girlfriend. Lois had never seen Ernie before. Ernie exited his vehicle and approached Lois. He forced her into the back seat of his car, drove 20 minutes into the desert, and committed an assault of a sexual nature. Ernie drove back to Phoenix and dropped her off. He said to her, "Pray for me." Lois ran to her residence and informed her family, who notified the police. Lois told the police that the vehicle her attacker was driving was green or gray with dark upholstery. Her brother-in-law spotted that same vehicle in the neighborhood about a week later and obtained a partial license plate. The police were able to figure out that the vehicle belonged to Ernie's girlfriend. The police found Ernie at his girlfriend's residence on March 13. He agreed to come back to the police station and participate in a lineup. Lois was not able to positively identify Ernie as the man who attacked her, although she suspected it was him. The police lied to Ernie and told him that Lois positively identified him. They proceeded to interview him for 2 hours, but never advised him he had the right to have an attorney present. During the interview, Ernie confessed to the crime. He was eventually convicted. Ernie appealed his conviction, and on June 13, 1966, the United States Supreme Court reversed his conviction, saying that when police officers take a person into custody and ask them questions, they must inform the person that they have the right to consult with an attorney and the right not to be compelled to incriminate themselves. This warning became known as the Miranda warning. There are some variations in how the warning is delivered, but in general, it goes something like this. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to have an attorney. If you cannot afford an attorney, one will be provided to you. This warning must be read by the police when they conduct a custodial interrogation, which means when a person is under formal arrest or their freedom is restrained to a degree comparable with a formal arrest. Ernie Miranda was tried again, this time without his confession being admitted as evidence. The problem for Ernie is that his girlfriend decided to testify against him. She said that he confessed to her. So he admitted to her that he committed that crime. On March 1, 1967, he was convicted again and sentenced to 20 to 30 years in prison. Ernie was paroled in 1972. He started selling autographed Miranda warning cards for $1.50 each. Ernie continued with his life of crime. He was arrested for motor vehicle offenses and lost his driver's license. At one point, he was charged with possession of a firearm. He wasn't convicted of that charge, but this still represented a violation of his parole. He was sent back to prison and released in March 1975. On January 31, 1976, Ernie was in a bar in downtown Phoenix when he was stabbed in a fight. He was transported to Good Samaritan Hospital, the same hospital where I was born in 1972. It's a small world. Ernesto Miranda would die at that hospital as a result of his wounds. He was 34 years old. Now moving to my analysis. Here are my thoughts on a few items that stood out to me in this case. Item number 1. Often when people think of Ernesto Miranda, they envision the police coercing a confession out of a helpless and innocent citizen who was just minding his own business. In reality, Ernesto Miranda was a dangerous repeat offender who had a strong desire to harm women. Furthermore, he signed a confession and acknowledged that it would be used against him in a court of law. After his arrest, Ernie was diagnosed with schizophrenic reaction, which these days is known as schizophrenia. However, he still understood the difference between right and wrong. He was also diagnosed with sociopathic personality disturbance, which is now referred to as antisocial personality disorder. Ernie was described as immature, unstable, impulsive, sadistic, and unable to control his behavior. The Miranda versus Arizona case was not about Miranda being innocent. Rather, it was about the rights that anyone should have when they're being questioned by the police. In the end, the ruling didn't actually help Ernie. He ended up being convicted again and eventually being murdered. He made a few dollars selling those Miranda warning cards, but that was the only benefit he received from the Supreme Court decision. Item number 2. In June of 2022, the Supreme Court made a ruling which weakened the effect of the Miranda case. They concluded that if law enforcement fails to give somebody a Miranda warning, the person does not have the right to sue law enforcement for a federal civil rights violation. Essentially, this ruling means that the police do not have to face consequences for violating the law. Item number 3. The courts have traditionally not been very generous to people who claim that they were not aware of their own rights. Sometimes it really feels as though the court wants a person being questioned by the police to say the exact words to assert their rights. I want a lawyer, and I want to remain silent. This is exemplified by the Demaine case from Louisiana. In October of 2015, 22-year-old Demaine was being interrogated by the New Orleans police after 2 young girls said that he attacked them. This was the second time he had been questioned by the police, and he was getting frustrated. He repeatedly denied being responsible. Here's what Warren said to the detectives, quote, "This is how I feel. If y'all think I did it, I know that I didn't do it, so why don't you just give me a lawyer, dog? 'Cause this is not what's up," unquote. The police continued to question Warren, and he eventually confessed, which led to his arrest. His public defender filed a motion to suppress his statement, under the idea that Warren had invoked his right to an attorney. He did say the words, "Give me a lawyer," but the police continued with their questioning. The problem for Warren was that he added the word dog. He said, "Give me a lawyer, dog." The Supreme Court of Louisiana ruled that Warren's reference to a lawyer did not constitute an unambiguous invocation of his right to counsel. Essentially, the court was saying that the police officers may have understood that Warren was invoking his right to counsel, but they couldn't be certain because Warren may have been referring to a lawyer dog. This, of course, is ridiculous. Clearly, lawyer dogs do not specialize in criminal defense. Rather, they become personal injury attorneys. After all, dogs like chasing cars, and personal injury attorneys like chasing ambulances. There is quite a bit of overlap there. No self-respecting lawyer dog would forego a career in personal injury to study criminal law. This would be as ludicrous as a lawyer shark abandoning their study of maritime law. The police should have known this and not questioned Warren anymore. Or they should have known that he meant, give me a lawyer, comma, dog. Like the words lawyer and dog were separate, and there never was a lawyer dog involved in the situation. Evidently, these police officers did not have verbal comprehension skills. It's a sad testament to the state of the courts and to law enforcement when society cannot assume that they understand basic grammar. What if Warren had said, just give me a lawyer, dude? Would this have been less confusing for the police, or would they have stood there and said, what's a lawyer, dude? I think the lesson learned from this particular case in Louisiana is that when people are being questioned by the police, they need to be clear when asserting their rights. They shouldn't say things like, maybe I need a lawyer. It sure would be nice to have a lawyer. I wonder what a lawyer would think about this situation. Hey, do you have any lawyers around here? Or, you know what would make a nice addition to this interrogation? A lawyer. Instead, the person should say, I want a lawyer, followed by a long pause, so that the police don't run out and try to find a lawyer dog. Item number 4. Not everybody agrees with the Miranda warning. For example, Miranda versus Arizona was a 5-4 decision. Some people believe that citizens should be responsible for knowing their rights regardless of what the police tell them. I look at this differently. I don't think the police should ever be able to question anyone without a lawyer present, no matter what. It's estimated that 25% of wrongful convictions are the result of police eliciting false confessions. The tactics the police use to coerce suspects to confess discriminate against people with disabilities. For example, if somebody has an anxiety disorder, they are much more likely to confess. It worries me that law enforcement officers are dependent on deceiving and manipulating people in order to get convictions. It's bizarre that we have reached this point where, even when a suspect mentions a lawyer, that's not good enough. They have to say the exact words and not mention any canines, or the interrogation will continue. If the discussion has descended into the area of lawyer dogs, perhaps it would just be easier to let everybody have a lawyer human before questioning proceeds. Those are my thoughts on Ernesto Miranda and the Miranda warning. Please put any opinions and thoughts in the comment section. They always generate an interesting dialogue. As always, I hope you found my analysis to be as intriguing as a dog with an atypical career path in the law. Thanks for watching.